well, it's all the school's fault. If the school would have handled this differently, nobody would be here. Well, that's not the facts. The fact is that the defendant walked into that school with a gun, with ammo, with drugs on November the 8th, 2005. That's undisputed. Is it the school's fault that the defendant cocked the gun? That he took the safety off? That he pulled the trigger? Exhibit number 30. Mr. Pierce's notebook. The very last entry. Kenny Bartley may have a gun. Here's another distraction. Let's put up a picture of a young boy. Let's put that picture up and let's talk about it a whole lot. Talk about how he's 14, 14, 14, 14, 14. Anybody hadn't got that he's 14? We don't dispute he was 14. The judge is going to give you these jury instructions in a little bit. I challenge you to look through it and see if it ever says anything about the defendant being 14. The same law applies to him as applies to everybody else. Nothing in here about being 14. It's a distraction to keep you from focusing in on the facts that you've seen and you've heard. Let's distract you from the facts that you've heard by talking about inconsistencies. These are the two charts filled out by Mr. Pierce and Mr. Seal. Now, the only inconsistency I can see is when Susan Phillips said, "There's a B right here for Bartley." She's the only person that says that, and the defense wants you to look at her testimony, and I do too. Because she's a lady who has not returned to work at all after this event. Not worked a day since this event. This event affected her. We'll use this again in another minute. Remember in voir dire, when I was speaking to you and talking to you about whether you can tell if somebody's lying to you or not. It's been a week ago. You look at their body language, you look and see if it corresponds with the facts and the things that you know. Can it be substantiated? Do they look animated? Do they look like a robot answering questions? How do they appear to you? And you've been able to watch all of the witnesses here on the witness stand. And that's an evaluation that you have to make based on your common sense. The defense would like for you to believe that Mr. Pierce and Mr. Seal are lying and that the defendant has told the truth. Let's look at the evidence that's been entered. we did a lot putting in pictures and forensic evidence of the scene, because that's applicable. Where people were when they were shot, Mr. Seal says he was back here in this seat when he was shot in the groin. He had extensive surgeries and repairs. There's no doubt that he was shot. And that the testimony is that he was seated in this seat. There's also a bullet found underneath this seat. There's also a bullet in this wall up here. And I was referring to Exhibit 17. Now referring to Exhibit 12. You've also heard that Mr. Bruce was found back in this area. And one of the witnesses even marked Bruce right here. There's also a shell casing found here. And if you'll recall, referring to Exhibit 19, a shell casing found here, which is right up here in this large picture. You can see the Sprite bottle and the Pepsi bottle, and the Sprite bottle, I'm sorry, it's Diet Pepsi, and the Diet Pepsi bottle. Mr. Bruce was shot, as Dr. Malusinick testified, back at the shoulder, contact wound. A contact wound to the back of the shoulder of Mr. Bruce in the back corner of the room. A contact wound means that the gun is placed up against the skin in such a manner as the gunpowder actually goes into the wound, and you can see the darkening parts of the gunpowder. That's the testimony from the medical examiner. She also testified that his hands were up and that it was at a downward angle, that the shooter had to be above the victim. So that's a contact wound to the back of the shoulder in a downward fashion. And that contact wound is exhibit number 47. Who else told you about Mr. Bruce's hands being up? Mr. Seal told you that. He said, I remember his hands were up. Now let's think about for just a minute, whose testimony is inconsistent with all that? Whose testimony is inconsistent with anything at all happening in the back of this room? When the defendant testifies, he gets the same weight as all the other witnesses. You judge his credibility just like you do everybody else. And you know what? You remember what the defendant told you? I marked it with a B on exhibit number 31. He said he was right here. How do you accomplish a contact wound in the back of a man from an upward angle from this point in the room? Now, one of the defendant's versions of his stories. One of several versions, actually. First thing he told was when he saw Detective Mongar, he said, if I hadn't taken Xanax, none of this would have happened. That's the first thing he told. You each have in your pocket a copy of Exhibit number 38. Toxicologist testified to you that the only thing in his system was found to be diazepam, which is Valium. No Xanax. No Xanax. The other thing that the defendant freely admitted to you on the stand was that here in this sign-in sheet, he put that he went to the doctor, and that was a lie. So we've got that lie, and we've got the Xanax lie. What else do we have? Let's get a bigger version of what the defense was showing you as a hospital record. And the thing that the defense doesn't want you to see when they're reading it, and they say took the gun out of his pocket and felt scared and shot randomly, this next line says, at 3 people. How do you shoot randomly at 3 people? I had to go look up random because I thought, obviously, I don't understand the definition of this word. And random means without aim. How do you shoot randomly at 3 people? He also told that he had been taking the medication OxyContin off and on. Well, let's see. Got his toxicology report here, and this says diazepam, and I was told that was Valium. No OxyContin in his system. That's another lie. He told that he was sick, so he needed to stay home from school. But then he said, no, he really wasn't sick. He'd had a soma the night before. Oh, wait, did he say soma on here? Any medications? He said OxyContin. Nope, he didn't say soma. He didn't even say Xanax, and that's what he said just a little bit before that. So he said Xanax, he says OxyContin, he says somas. He also said he was too sick to go to school that morning, but then he went later on that afternoon. You know why he had to wait to go to school. He couldn't go in the room and get the gun when his dad was still there. It's his dad's bedroom where the gun was hidden. His dad's not going to let him go in there and get the gun while he's in there. So he's got to wait till his dad's gone. He's got to wait till he's home alone so he can get the gun and get the bullets and get the clip and get the drugs and go to school with the drugs and the gun. Now, he also says, let's see, does it say Bill Crowley on this? Brought gun to school today, intention of selling school in trade for OxyContin. Yeah, he doesn't say Bill Crowley up here, does he? He's pretty adamant about Bill Crowley now, but he never mentions it there. He also told you that Bill Crowley's house was a 2 to 3 minute 4-wheeler ride away from his house. He told you that he rode his 4-wheeler to his dad's store. So, really, if his intent was to trade the drugs to Bill Crowley, why didn't he just go do that? His intent was to go to school with drugs and a gun. Because he's not just little Kenny Bartley. He's a drug dealer. He's got his pills. He's got his gun. And he sat here and told you, the first class he was in, he told Aaron Crowley, guess what I've got? Brought me a gun to school today. Aaron Crowley didn't tell. Next two people that found out, Preston and Daniel, they kind of found out by accident. And he told them, don't tell. It's a gun, don't tell. But they told. They told. He actually showed it to Trent McCulley. Check this out. Right before he crushed up those tablets and was dividing them all up so that they could each snort a line of Xanax. Is that what a drug dealer does? They carry a gun and they distribute drugs to other folks? And, you know, a drug dealer doesn't let anybody disrespect them, do they? When he's in that office, and he's sat in there for quite some time, and he's got all these steps that he's taken to get that gun to school, get those drugs to school, do what he's going to do. And he sees the boys leave the back office. He's coming in this way, and he sees them leave that way. He knows the jig is up. And if I can for just a minute, let me show you again. Let me show you the defendant both before and after the crime. The first video is before, and you will see the defendant and SRO Susan Phillips checking the attendance sheet and then going in the office. And this is exhibit number 1. There they come out the door. They check the attendance. They're chatting. Very casual. Little Kenny Bartley is just as big as SRO Susan Phillips, isn't he? Now let me show you after the event. This is the front office of the school. We saw this video earlier. Just a normal day. People coming in and out, talking on their phones. There went Johnny Thompson with his attendance records. There goes Danny Shekels into the office. In just a minute, you'll see Bob Walden go into the office. There went Bob Walden with the dark shirt on. You see law enforcement arrive. And you see the defendant brought out. And I'll let you watch this in its entirety. Does he seem panicked to you? Any signs of shaking or fright because he was scared? Or is he just calm? Exhibit number 1, ladies and gentlemen. Calm, cool, unfazed the whole time. How many witnesses told you he was calm? He was calm, he was calm. One witness told you that while he was on the ground and was being restrained, and as they were bagging Mr. Bruce behind him, he was complaining about his own hand hurting. Another witness, Bob Walden, said that he'd secured the weapon and that it was a .25, and the defendant corrected him. It's a .22. He also said, "What's your name?" And he said, "Kenneth Bartley." No hesitation, no crying, calm, calm. Now, we talked about his first story to Daryl Mongar with the Xanaxes. We talked about the second story here to the hospital. Let's talk about the third story, which would have been, the third story was his story here on the stand, when he took the stand and testified before you, and said that he only moved this far into the office. Did you hear him talk about Mr. Bruce? He said he came in the office. He didn't say anything about Mr. Bruce, did he? Because he can't explain away how he randomly shot point blank in the back Mr. Bruce. Didn't even talk about it. It's like he didn't exist.
Can I see what you have, gentlemen? I have no objection.
Ladies and gentlemen, this is Ken Bruce. He taught at that high school for 13 years after serving in the military. You didn't hear from him from this witness stand today, did you? He didn't get a chance to tell you what happened, did he? He didn't even say a word in that room. That's Ken Bruce. The defense wants you to think that this is all about Kenny Bartley. And we've looked at his picture all week long. Well, ladies and gentlemen, we're here because Ken Bruce was shot with a contact wound and died in that room that day. And he didn't get a chance to be here to tell you his story. Now, when the defendant took the stand, he didn't even talk about Mr. Bruce, because he can't, because the story's not plausible. You can't randomly shoot somebody at point blank range. And if you're shooting random, you shot everybody in that room. There wasn't a single person in that room that didn't get shot. The testimony of the witnesses that correspond with the forensic evidence is the testimony of Mr. Seal and Mr. Pierce. They say that the defendant was seated in his chair, went down, got the gun, and walked Mr. Bruce to the back of the room. You didn't hear the defendant say that, did you? But when I asked him about his statement that he gave to Detective Farmer, he recalled. And then I pulled it out and I pointed it at Mr. Seals and I told him to get back. And I just kept pointing at him and telling him to get back. And I walked to the back of the room. And I cocked it and I turned the safety off. And as soon as I did that, I pointed it at Mr. Seals and I shot him. And I pointed it again and I can't, it's hard to remember. I just pointed it and shot it again, and then I pointed it at the guy that was like below me. And I shot it and I shot it. I'm not really for sure how many times I shot at each person. This was a statement to Don Farmer. Much unlike his testimony before you yesterday. The defendant told Daryl Mongar, "I ruined my life." My life is what he said. What about this life? What about Ken Bruce? What about not even acknowledging him in his own testimony? Ken Bruce was forced at gunpoint to the back of the room by the defendant, who then turned around, and when Mr. Seal says, "Is that gun even real?" he made two statements. And that's really all you need in this case, those two statements. "I'll show you it's real. I never liked you anyway." And with those two statements, he shows you his intent to kill Mr. Gary Seal. "I never liked you anyway. I'll kill you right now because I never liked you anyway. I'll show you it's real. I brought these guns, this gun and these drugs to school today, and you're not going to tell me that it's not real. I'll show you that it's real. I never liked you anyway." And he proceeded to shoot at Mr. Gary Seal twice. Bang, bang. And then he turned and he fired on Ken Bruce back in the corner. Bang. And Mr. Pierce comes out of his chair and he shoots Mr. Pierce. Bang. As he and Mr. Pierce go to the floor, there's another bang. And the defendant has a mark on his hand where his hand is shot. It's all about the defendant, right? My hand's hurting. I've ruined my life. If I hadn't taken those Xanax, he's sorry yesterday, but he wasn't sorry then. He's sorry when it's convenient. Did he say he was sorry here? Were his eyes red or discharged crying, anything? Was he confused, depressed, agitated, suicidal? Nope. 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 Not confused. Except except that he shot randomly at 3 people. Ladies and gentlemen, the state has proven our case to you. We've given you plenty of evidence of the defendant's conscious choices and steps to get him to that room with that gun, to look at Mr. Pierce and utter those words. He intended to kill Mr. Seal. And he intended to kill Jim Pierce. And he shot Ken Bruce at point-blank range. He intended to kill Ken Bruce. Don't be swayed by all the distractions. 14, got her own story, scared, random. This was a purposeful firing. Look at the forensic evidence. What they want you to see is a shooter who's having to self-medicate. And what he really is a liar and a murderer and a drug dealer. He brought a loaded gun to school and he brought drugs to school. We've given you plenty of proof to find him guilty of first-degree murder. We've given you plenty of proof to find him guilty of felony murder. We've given you plenty of proof to find him guilty of attempted murder of Gary Seal. We've given you plenty of proof to find him guilty of the murder of Jim Pierce. And we ask that you do so. Thank you.
Let's take a few moments to get over the paraphernalia. Ladies and gentlemen, defendant Kenneth Bartley is charged in the indictment of murder in the first degree, which necessarily includes the lesser offenses of second-degree murder, voluntary manslaughter, and reckless homicide. In count 2, the defendant is charged with murder in the perpetration or attempt to perpetrate murder in the first degree, which necessarily includes the lesser offenses of second-degree murder, voluntary manslaughter, and reckless homicide. In counts 3 and 4, the defendant is charged with attempt to commit first-degree murder, which includes the lesser offenses of attempt to commit second-degree murder and attempt to commit voluntary manslaughter. In count 5, the defendant is charged with possession of a handgun with the intent to go armed on school property, which necessarily includes the lesser offense of possession of a prohibited weapon. In count 6, the defendant is charged with possession of controlled substance with the intent to sell, which includes the lesser offense of simple possession. In count 7, the defendant is charged with possession of a controlled substance with the intent to deliver, which necessarily includes the lesser offense of simple possession of a controlled substance. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence in this case has been completed, and it's now the court's duty to instruct you on the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The indictment in this case is a formal written accusation charging the defendant with a crime. It's not evidence against the defendant and does not create any inference of guilt. At times during the trial, the court has ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any other mark which the court has made to support me to indicate any opinion as to what the facts are or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law in the direction of the court. You should apply the law to the facts and decide in this case. You should consider all of the evidence in the light of your own observations and experiences in life. The law presumes that the defendant is innocent of charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has a burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense or offenses. The state must have proven beyond a reasonable doubt all the elements of crime charged, and it was committed before the finding and returning of the indictment in this case. The burden is on the state to prove by preponderance of the evidence that this offense was committed in Campbell County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was commenced or consummated in Campbell County, Tennessee, your verdict would be not guilty. First-degree premeditated murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, and that the defendant acted intentionally. A person acts intentionally when it's a person's conscious objective to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result of the death of a person, that he did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And number 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Number one, that the defendant unlawfully killed the alleged victim, and the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established to show that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's a person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause or result the death of the person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter, any person who commits voluntary manslaughter is guilty of a crime. If you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements. That the defendant unlawfully killed the alleged victim, that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Knowingly means that a person acts with awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's a person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of the person, that he did so as a result of a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner, then the killing of another, even if not the intended victim, would be voluntary manslaughter. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant killed the alleged victim and that the defendant acted recklessly. First-degree murder, killing, and the perpetration of other crimes. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. That the defendant unlawfully killed the alleged victim, and that the killing was committed in the perpetration of or the attempt to perpetrate the alleged first-degree murder. That is, that the killing was closely connected with the alleged first-degree murder and was not a separate, distinct, and independent act, and that the defendant intended to commit the alleged first-degree murder. Murder in first degree is heretofore defined to you. The court will define the attempt of first-degree murder later in these instructions. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factor as time, place, and causation is helpful in determining whether the killing was committed in the perpetration of the alleged first-degree murder. Killing may precede, coincide with, or follow the first-degree murder, or attempt to commit first-degree murder, and still be considered as occurring in the perpetration of the attempt to commit first-degree murder, so long as there is a connection in time, place, and continuity of action. Intentionally means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it's a person's conscious objective or desire to engage in conduct to cause the result. Criminal attempt. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of a criminal attempt, the state must have proven beyond a reasonable doubt the existence of following elements: that the defendant intended to commit a specific offense of murder in the first degree, and that the defendant did some act to cause something to happen that would have constituted murder in the first degree if the defendant's belief at the time he acted had in fact been true, or that the defendant did some act intending to cause an essential element of murder in the first degree to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended means that a person acts intentionally when it's a person's conscious objective or desire to cause the death of the dead's victim. The essential elements necessary to constitute murder in the first degree and its lesser included offenses have heretofore been defined. Any person who commits the offense of possessing a weapon with the intent to go armed on school property is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements: that the defendant possessed either openly or concealed a firearm not used solely for an instructional or school-sanctioned ceremonial purposes, and the defendant was in or on school property, and that the defendant had the intent to go armed, and the defendant acted either intentionally, knowingly, or recklessly. Possessions of a weapon. Any person who unlawfully possesses a prohibited weapon is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant possessed a device principally designed, made, or adapted for delivering or shooting an explosive weapon, and that the defendant acted intentionally or knowingly. Any person who knowingly possesses with the intent to deliver or sell a controlled substance is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly possessed alprazolam, a Schedule 4 controlled substance, and that the defendant intended to deliver or sell such controlled substance. Alprazolam is a Schedule 4 controlled substance. Any person who commits the offense of simple possession is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements: that the defendant knowingly possessed a controlled substance, and that the substance was alprazolam, a controlled substance. Alprazolam is a Schedule 4 controlled substance. Intentionally means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it's a person's conscious objective or desire to engage in conduct or cause a result. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is leading certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or result of the conduct when the person is aware of it consciously disregards a substantial and justifiable risk that the circumstance exists or the result will occur. The result must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. School property includes any public or private school building or bus, or any public or private school, campus, ground, recreation area, athletic field, or any of the property owned, used, or operated by any Board of Education, school property, or University Board of Trustees, regents, or directors, or the administration of any public or private educational institution. Deadly weapon means any firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in its manner of use or intended use is capable of causing death or serious bodily injury. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily converted to that use. Explosive weapon means an explosive, incendiary, or poisonous gas, shell, missile, or projectile that is designed, made, or adapted for the purpose of inflicting serious bodily injury, death, or substantial property damage. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconscious, physical extreme physical pain, protracted or obvious disfigurement, protracted loss or substantial impairment of the function of a body member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness or impairment of the function of a body member, organ, mental faculty. Sale or sale means a bargain for offer and acceptance and an actual or destructive transfer or delivery of the substance. Delivery or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. In reaching your verdict, you shall first consider the offense charged in count number 1. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty of that offense. If you unanimously find that the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the defendant's guilt as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to determine the next count of the indictment in the same order of consideration. Crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. During the course of the trial, you've heard the expert testimony of various experts described as experts in their field. The rules of scientific evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. Same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend upon your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions are based on sound reason, judgment, and information. You are to give the testimony of expert witness such weight and value as you think it deserves, along with all the other evidence in this case. The guilt of the defendant, as well as any fact required to be proven, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact and issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact and issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give to direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is better evidence than the other. You should consider all the evidence, both circumstantial and direct, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness is sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof of any of his or her general character, the evidence of any of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his and her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all of the evidence in this case tending to corroborate or contradict him or her. The defendant having testified in his own behalf, his credibility is determined by the same rule by which the credibility of the other witnesses is determined, and you will give his testimony in such ways you think it is entitled. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of a matter asserted in such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statement of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has a right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself. Do so only after a partial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence solely because of the feeling of your fellow jurors for the mere purpose of returning a verdict. You can have no prejudice or sympathy or anything but the law and evidence have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as a full person who will preside over your deliberation. When you have reached a verdict, you will return to this court and the full person will deliver the appropriate verdict form to the court. If you find the state has found the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find the state is not proven beyond a reasonable doubt the defendant's guilt or have to give a reasonable doubt as to his guilt, then you must find the defendant not guilty. Ladies and gentlemen, the verdict forms that you will receive read as follows. Count 1. We, the jury, find the defendant Kenneth Bartley, and you will circle the appropriate one, guilty of first-degree murder of Ken Bruce, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or not guilty. Count 2. We, the jury, find the defendant Kenneth Bartley, circle the appropriate one, guilty of murder of Ken Bruce in the perpetration or attempt to perpetrate first-degree murder of Gary Seal and Jimmy Charles Pierce, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. Pardon me. Please do not disregard my reference to guilty of criminally negligent homicide. That's not applicable. Count 3. We, the jury, find defendant Kenneth S. Bartley guilty of attempt to commit first-degree murder of Jimmy Charles Pierce, or guilty of attempt to commit second-degree murder, or guilty of attempt to commit voluntary manslaughter, or not guilty. Count 4. We, the jury, find defendant Kenneth S. Bartley guilty of attempt to commit first-degree murder of Gary Seal, or guilty of attempt to commit second-degree murder, or guilty of attempt to commit voluntary manslaughter, or not guilty. Count 5. We, the jury, find defendant Kenneth S. Bartley guilty of possession of a firearm with the intent to go armed on school property, or B, guilty of possession of a prohibited weapon, or not guilty. Count 6. We, the jury, find defendant Kenneth S. Bartley guilty of possession of a Schedule 4 controlled substance to wit alprazolam with intent to sell, or guilty of possession of controlled substance, or not guilty. And finally, count 7, we, the jury, find defendant Kenneth S. Bartley guilty of possession of Schedule 4 controlled substance to wit alprazolam with the intent to deliver, or be guilty of possession of a controlled substance, or not guilty. Ladies and gentlemen, I will remind you that if you have taken notes in this case, those notes are used to refresh your recollection, but they are not to be read to any of your fellow jurors. As I've stated before, your notes may contain errors or may not be a complete transcription of the witness's testimony, so you are free to refresh your recollection. However, you are not free to read to your notes to your fellow jurors. If during the course of your deliberations you have a question regarding the law in this case, you may reduce that question to writing and inform the officer that you have a question regarding the law, and the court will then look at your message or your written message, and I will attempt to answer that message or that question as best I possibly can. This court cannot answer any questions that relate to the facts of this case. Ladies and gentlemen, you will have in the jury room these instructions, and you are free to read or reread any portion of the instructions that you might feel might help you in your deliberations. Also located in this book will be the verdict forms that I have just read to you. When you have reached a verdict and you have executed the verdict forms, you will return the verdict forms back into this notebook. You will then announce to the officer outside the door that you have reached a verdict in this case. And then you will hand, after you've done that, you will hand this notebook containing the verdict forms back to the officer that you can notify that you reached your verdict. When you are brought back in open court, the officer will deliver this notebook with the verdict form in it to me. I will review the verdict form to make sure it's been properly executed, and then I will return the verdict forms back to the foreperson, who will then stand in open court and read your verdict to the court. Now, ladies, you two alternate jurors, you are hereby discharged from any further service in this case. I want to thank you for your service as jurors, and you really have two decisions to make. One is you're free to go about your business. If you would like to go back to Chattanooga at this time, there will be an officer ready, and he will be able to take you back. If, however, you would like to wait and to wait on the verdict in this case, you're free to do so. If you do wait, then you will be also fed, and you'll be fed, regardless of whether you're in Chattanooga or not, but you'll be fed as a jury out in the state. You'll be denied any food. But the decision is whether or not you want to stay around. If you do, you're free to do that. But if you'd like to go back to Chattanooga, they'll make arrangements to deliver lunch to you, and then you can go back to Chattanooga. But you may not go into that jury room, and you may not at any point have any deliberations with him. There is one other issue I need to talk to you about. Next, please. The last thing I need to tell you, ladies and gentlemen, you have in your notebook various exhibits that they have allowed you to keep. If you wrote anything on those exhibits, they're for your use only. You cannot share with the other jurors anything that you may have written on the notebook. Ladies and gentlemen, if you're free now to retire to begin your deliberations, there'll be some other exhibits that if they're not in the book, that you'll be able to carry back there with you. But this time you may retire to begin your deliberations. If you two would make your minds up with regard to the to whether you want to go back or not, you have to retire to begin your deliberations. All rise. Yeah, if you'll be allowed to go in there and just get your stuff and come back.
Okay.
We'll stand in recess.
Court's in recess.